here, we are looking at how to prepare the proper ethical and legal foundation for our businesses. The proper ethical and legal foundation for our businesses. And we'll need to have some objectives in place so that we can set the ball rolling. The first objective we shall have on today's discussion is you will need to be able to describe how to create a strong ethical culture in an entrepreneurial venture. 2, explain the importance of leading by example in terms of establishing a strong ethical culture in a firm. Explain the importance of having a code of conduct and an ethics training program. Explain the criteria important to selecting an attorney or lawyer for your new firm. Describe the importance of a founders agreement. Number 6, provide several suggestions for how entrepreneurial firms can avoid litigation. Discuss the importance of non-disclosure and non-compete agreement. Provide an overview of the business licenses and business permits that your startup must obtain before it starts conducting business. Discuss the differences among several proprietorship, partnership, corporations, and limited liability companies. So the type of company you want to set up, you need to understand it. So you can understand the advantages and its disadvantages. So you can evaluate different types of business organizational types. And then the last objective is to explain why most fast-growing entrepreneurial ventures organize as corporations or limited liability companies rather than sole proprietorship or partnership. You need to understand that this development, and they will guide you to a very large extent. So we want to look at 6 ethical and legal issues that face every new firm. 6 ethical and legal issues that face every new firm or venture. The first one is establishing a strong cultural, ethical culture. The second one is choosing a lawyer or an attorney for your firm, organization, or company. The third consideration is how to draft a founders agreement. So probably you have 3 founders, you have 2 founders, you have 4 founders. You don't need to just work on the basis of trust only. There need to be some evident document that underlies what you have all come together or you have teamed up together to do. The 5th element that we'll look at is how to avoid legal disputes. 5, how to obtain business licenses and permits. And 6, how to choose a form of business organization that is best suitable for your mission or your strategy. So these are the 6 ethical and legal issues that every organization or business firm is confronted with. And you need from the word go decide on some of these issues. So by starting, how do we establish a strong ethical culture? One of the basic or fundamental way of establishing a strong ethical culture is leading by example. Leading by example. The most important thing that any entrepreneur or team of entrepreneurs can do to build a strong ethical culture in their organization is to lead by example. You cannot expect your employees to live a certain lifestyle to build a culture of your business or of your firm. You need to be deliberate about your business culture, your firm's culture, and you need to do everything possible to build a culture that you expect in your business place in the future. And the best method, the primary way of doing that is leading by an example. The second way of establishing a strong ethical culture is establishing a code of conduct. A code of conduct or code of ethics is a formal statement of an organization's value on certain ethical and social issues. Your organization's value. What are values to your organization? You should draft them down. You should know what you hold as dear to you as values, that if you should employ them in the workplace, will make you more efficient and appear more ethical in your workplace, which will also inure to your benefit or enhance customers' interest in your organization. The third issue is, or the third way of implementing or establishing a strong ethical culture is how to implement an ethics training program. Ethics training program teach business ethics to help employees deal with ethical dilemmas and improve their overall ethical conduct. So probably what you want to do, if for instance you want to have all the three, then it is important to also train your employees to know exactly what to do and the sort of conduct they need to display at the workplace. An ethical dilemma is a situation that involves doing something that is beneficial to oneself or the organization, but may be unethical. So sometimes an individual, that is the employee or employees, may do something that is beneficial to them, or the organization as a whole will do something that is beneficial to the organization, but it may not be ethical. These considerations need to be looked at closely and carefully when you are establishing your ethical culture in your organization. There are some potential payoffs or benefits for establishing a strong ethical culture. If you have an ethical culture, a strong ethical culture, it may not bring you money, but there are some values it will bring you. So a strong ethical culture can lead to 1. Avoidance of fines, potential avoidance of fines. 2. It can lead to a better access to capital, because if you have an strong ethical culture, there are some organizations that believe in ethics. Today we are talking about social ethics, sustainable ethics. We are talking about so many issues that concern about business impact on the environment. And these ethical issues need to be taken very seriously. Research has shown that today's buying generation or Gen Zs will prefer to buy from an ethical or do business with an ethical organization or an ethical firm, which means that there are funds that are dedicated solely for companies that are ethical or have strong ethical culture to have access to. You may not know, but practicing or building or establishing strong ethical culture can open those doors or avenue for your company. A third benefit or payoff, potential payoff that your firm can derive from by building or establishing a strong ethical culture is improve brand reputation. Your brand reputation improves. The third is you improve employees' commitment. There are many employees in today's economy, in today's 21st century, who will want to work with an organization that is ethically oriented. So it improves the employee commitment to the organization. The fifth item, or the fifth payoff or possible benefit, is that it improves customer loyalty. So customers that are much interested in organizations that conduct business ethically, they will want to stick to you. So they become loyal. Then the sixth benefit is it leads to decreased vulnerability. Your vulnerability decreases. So it pays off to be ethical as a firm. So that is the first ethical and legal considerations every organization or firm or entrepreneur or entrepreneurs or group of entrepreneurs thinking to undertake a practice, a business, need to consider. The second thing to look at or to examine or to pay attention to as an ethical and legal demand is how to choose an attorney or a lawyer for your firm. It is important to select an attorney early at the beginning of your business. So I'm talking about attorney, I'm talking about a lawyer. So depending on which cultural environment you are. It is important for an entrepreneur to select a lawyer or an attorney as early as possible when developing a business venture. Do not wait for the business to grow and begin to have difficulty in the public space or become prone to some ethical demands or become confronted with very dating issues before looking for a lawyer. So right from the word go, as you are pondering over starting a business venture, think about choosing an attorney right from the beginning. It is critically important that the attorney is familiar with startup issues. So do not just go in for the sake of getting a lawyer or selecting a lawyer for your business to go in for anybody. You need to understand that all lawyers have their practical specializations or areas that they are very good at. So the best lawyers to look for your business are those that understand startup issues. They are familiar with startup issues. Then you also have to think about your intellectual property. Because for issues dealing with intellectual property, such as patent, trademarks, copyright, and then trade secret, it is essential to use an attorney or lawyer who specializes in this field. So I believe you are seeing the reason why you need to choose a lawyer, to have a lawyer right at the beginning of the business. So if you want to protect your intellectual property, choose a lawyer, an attorney that understands this area very well. How then do you start by choosing an attorney or a lawyer? How do you select a lawyer? Let's look at some few practical issues you need to consider when you're selecting a lawyer for your firm. Number one, contact the local bar association and ask for a list of attorneys or lawyers who specialize in startups in your area. So look at your geographical location. You don't need to go far because it becomes expensive hiring a lawyer or an attorney from a very far distant area. 2, interview several lawyers. Be prepared to interview several lawyers, several attorneys. Interview them. When you get to interview them, you will know their areas of specialization or areas of interest, areas of focus. Then you will know who will be right for your business. Number 3, select an attorney who is familiar with the startup process. So the process involved in setting up a startup business. Select a lawyer, an attorney who understands that, who's familiar with that. Number 4, select a lawyer or an attorney who can assist you in raising money for your new venture. So you do not just select lawyers for lawyers' sake. The lawyer should be able to assist you to raise funds for your business. Number 5, make sure your attorney has a track record of completing his or her work on time. There are some lawyers that are not good at it. They are always up with unfinished businesses. They start these, they do not finish. You go in for such a lawyer, you'll be dragging your venture behind. You cannot go forward. So investigate very well and be sure that the attorney, the lawyer you are choosing, you are selecting for your business, has the track record of completing any task he or she engages in. Number 6, talk about the fees. How much will be charged? Lawyers do not render free services. And even if they render free services to you from the beginning, they expect to earn something at the end. Everyone giving a certain level of service, professional service, is expected to be paid. So talk about the fees. How much is involved? How much will you be talking about? Number 7, select a lawyer or an attorney that you think understands your business. Understands your business. And then number 8, learn as much about the process of starting a business yourself as possible. Starting a business yourself, you need to learn a lot about that. You need to know a lot about that. Now we come to the third issue when it comes to the legal and then the ethical considerations you as an entrepreneur will need to be considering. That is how to draft the founders agreement. Talking about a founders agreement or a shareholders agreement, you are talking about a written document that deals with issues such as the relative split of the equity among the founders of the firm. How are you going to split the equity among you, the founders of the firm? How individual founders will be compensated for the cash or the sweat equity they put into the firm? And how long the founders will have to remain with the firm for their shares to fully mature or vest? The items to include in the founders agreement include 1, the nature of the prospective business. What is the nature of the prospective business? The business you have undertaken or you are about undertaking. Prospective. 2, a brief business plan. So what should be involved in the founders agreement is what we are discussing. A brief business plan. 3, identify and propose titles of the founders. Each founder should have an identified title. 4, legal form of business ownership. You need to have legal form of business ownership. 5, appointment of stock. 6, consideration paid for stock or ownership share of each of the founders. 6, identification of any intellectual property signed over to the business. So 7, description of the initial operating capital. I'm taking time for you so that you will take these issues seriously, take note of them, and then you know what to do. The last but not the least I will talk about is the buyback clause. Will there be a time that you will need to buy back? That clause would need to be included. Let's talk about the 4th issue. Only they are talking about legal issues. Is how to avoid legal disputes. And when we are talking about legal disputes, then we are talking about misunderstandings, sloppiness, or a simple lack of knowledge of the law. Getting bogged down in legal dispute is something an entrepreneur should work hard to avoid. You have to do everything to avoid it. There are several steps that an entrepreneur you can undertake to avoid legal disputes. The first one is meet all contractual obligations. So if there are some contractual obligations that need to be met, please do everything possible to meet it. 2, avoid undercapitalization. Avoid it. 3, get everything in writing. So if you are somebody who is not used to writing, or who take things for granted, or who for the sake of your brilliance or intelligence would like to have everything at the back of your mind, you'll be making a huge mistake. Because tomorrow issue, when they are to be dealt with, they will not be processed from the mind. They will be dealt with from the records. So everything you do should be written down. Number 4, set standards. There must always be standards in place. Standards must be put in place. Although it is tempting to try to show people you trust them by not insisting on written agreement, it is not a good practice. You have to avoid it. For example, this is my friend. This is my brother. We are blood-born relatives. They are not the basis of making a contractual agreement. Contractual agreement, whether you trust the person or not, is not a good practice not to write it down. It should always be written down. So those of you listening to me are employers who are entrepreneurs, that other colleague entrepreneurs want to engage your services in some form of business, and you just trust them, and you have not demanded for an agreement, but you have given a nod to the idea, and you are giving it all your support. It is not a good practice. Demand that everything is put on an agreement. Everything is written into a partnership or founders agreement. One of the simplest ways to avoid misunderstandings and ultimately legal dispute is to get everything down in writing. Everything. So if you want to avoid dispute, that is the sure way. That is how to go about it. The fourth issue that we're talking about here is how to obtain business licenses and permits. Have you licensed your business? Have you obtained a permit for your business before going to undertake? Before going to start the entire process? You don't need to do something that is illegal, because at the face of the law, you will not be spared. Ignorance of the law is not. You can complete that for me. Business licenses in most countries, a business needs a license to operate. So look at your jurisdiction. I don't know if there is any country where you can start a business without needing a license to operate. So in most communities that I know of, you need a business license to operate. If the business will be run out of the founder's home, you also need a separate home occupation business license. A separate one. Some countries do not demand that, but some countries do. 3, if a business has employees or is a corporation, limited liability or limited partnership, it will usually need a license in addition to the very local one, which is very important. So a narrow group of companies are required to have also a business license, which include investments, advising, drug manufacturing, and then interstate tracking. These are very important, very, very important. So let's talk about the business permit. Along with obtaining the appropriate licenses, some businesses may need to obtain one or more permits. So check if your business, after obtaining the license, for instance, from the Registrar General Department, will it also be needful that you obtain further permits? Sometimes not one, sometimes 2, sometimes 3, sometimes 4, depending on the scope of the business. So the need to obtain a permit depends on the nature and location of the business, as I spelled out earlier. For example, if you plan to sell food, you will need a city health permit. In Ghana, for instance, you need Accra Metropolitan if it's within Accra, the city of Accra. If it is within the city of Kumasi, the Kumasi Metropolitan. If it is within a municipal assembly, then you will need a municipal permit. If it is within the district assembly, you need a district assembly permit to operate. And in some jurisdictions, you will need even health permit. And you will need some form of medical records to attest to the facts. If your business is open to the public, you may need a fire permit. So that is where you'll be referred to the fire service. There are certain businesses that are open to the public that will not be allowed to operate until they have that permit granted, or they have satisfied their fire permit requirement. Some communities require businesses to obtain a license to put up a signboard, for instance. Let's talk about the highways. You want to erect a signboard by the highway. Oftentimes, the district, the municipal assembly, or the metropolitan assembly would demand that you pay before you can erect that. If you do not pay, oftentimes it is raised down. All businesses that plan to use a fictitious name also need a fictitious business name permit. So pay attention to how to obtain your business permit well before you go ahead announcing your presence in the public space. Now we want to talk about how to choose the business form you are interested in. And we have basically 4 types of business form. We have the sole proprietorship, we have the partnership, we have the corporation, and then we have the limited liability company. So any of these companies you desire to launch, you need to understand them more effectively. So the issues to consider in choosing a legal form of business ownership include the cost of setting up and maintaining the legal form. The cost of setting up and maintaining the legal form. The second thing to think about is the extent to which personal assets can be shielded from the liabilities of the business. So these are issues you are considering in choosing a legal form of business ownership. Because going to register, the administration is not just going to register for you by looking into your face and say, hey, you are interested in corporation, so come for it. No. You need to know what you want and understand that. So the third issue to consider before choosing a legal form of a business ownership is the tax obligations. Then the fourth one is the number and types of investors involved. The number and types of investors involved. These are the issues that will play out when you want to choose a particular form of the legal form of business ownership. So let's talk about the sole proprietorship. The sole proprietorship deals with one person, and it is the simplest form of business entity that anyone can undertake. A sole proprietorship is a form of business organization involving just one person, and the person and the business are essentially the same. A sole proprietorship is not a separate legal entity. The sole proprietor is responsible for all the liabilities of the business, and this is a significant drawback. You are responsible for all the liabilities of the company. In itself, it's a disadvantage. So what are some of the advantages of owning a sole proprietorship business or establishing a sole proprietorship business? One, creating one is easy and inexpensive. So creating a sole proprietorship business is easy and it is not expensive. Two, the owner maintains complete control of the business and retains all the profits. So you, the owner, has complete control over the business and all the profits, hey, you have absolute control of it. Three, business losses can be deducted against the sole proprietor's other sources of income. So if you run into a business loss, you can deduct it from your other source of income. So it's another benefit. Four, it is not subject to double taxation. And this, we shall be looking at it, or we shall go into some detail to examine that. And then the fifth one is that the business is easy to dissolve. You can stop the operation of the business at any time. Unlike other types of legal forms of business ownership, you cannot easily dissolve them. So having looked at the advantages, let us also pay attention to some disadvantages of the sole proprietorship business. One, liability on the owner's part is unlimited. Right? It's unlimited. Two, the business relies on the skills and abilities of a single owner to be successful. So, of course, the owner can hire employees who have additional skills and abilities, but oftentimes it depends on your skills. So, if you don't have the skills, it means you're going to run down or at a loss. Number three, raising capital can be difficult if you're a sole proprietor. Number four, the business ends at the owner's death or loss of interest in the business. So that is the reason why you can find a lot of businesses in our part of the world always ending at the moment the owner dies, or when the owner loses interest or transfers interest into something else. Then the business comes to an end. The fifth disadvantage is that the liquidity of the owner's investment is low. So these are the disadvantages. So as much as there are advantages of considering the sole proprietorship, it is also important to consider the disadvantages before engaging into it. If you are more convinced and double sure about your decision, why not? Let's talk about the partnership business. With a partnership business, if two or more people start a business, they must organize as partnership or corporation or limited liability company. Partnerships are organized as either general or limited liability partnerships. Now, if you talk about the general partnership, it's a form of business organization where two or more people pool their skills, right, abilities, and resources to run the business. The primary disadvantage is that all partners are liable for all the partnership's debt and obligation. That's the primary disadvantage. Now let's talk about the limited partnership. The limited partnership is a modified form of general partnership. Here, the major difference between the two is that a limited partnership includes two classes of owners, general partners and the limited partners. The general partners are liable for the debts and obligations of the partnership, but the limited partners are only liable up to the amount of their investments. So let's look at some advantages of the general partnership. Creating one is relatively easy and inexpensive compared to a corporation or a limited liability company. The skills and abilities of more than one individual are available to the firm. 3. Having more than one owner may make it easier to raise funds. 4. Business losses can be deducted against the partner's other sources of income. And 5. It is not subject to double taxation. As much as we have advantages, there are also disadvantages. And these are some of the disadvantages. 1. Liability on the part of each general partner is unlimited. The business relies on the skills and abilities of a fixed number of partners. The owners can hire employees who have additional skills and abilities. But what about if the employees, their skills and abilities are not enough? 3. Raising capital can be difficult. 3. Because decision making among the partners is shared, disagreement can occur. 5. The business ends with the death or withdrawal of one partner unless otherwise stated in the partnership agreement. And 6. The liquidity of each partner's investment is low. So this brings us to the idea of what a corporation business is. A corporation is a separate legal entity organized under the authority of the state or the country. Corporations are organized as either C corporations or subchapter S corporations. C corporations are what most people think of when they hear the word corporation. However, business startups are often organized as subchapter S corporations. Business startups are often organized as subchapter S corporations. So, what is the C corporations? The C corporation is a separate legal entity that, in the eyes of the law, is separate from its owners. In most cases, a corporation shields its owners, who are called shareholders, from personal liability for the debts of the corporation. A corporation is governed by a board of directors, which is elected by the shareholders. A corporation is formed by filing articles of incorporation. A corporation is taxed as a separate legal entity. A disadvantage of a C corporation is that it is subject to double taxation. This means that a corporation is taxed on its net income, and when the same income is distributed to the shareholders in the form of dividends, the income is taxed again on the shareholders' personal tax returns. So this is what we call double taxation. So the corporation, the net income is taxed. So the dividends that you share among the founders is also taxed on the shareholders' personal tax returns. So that is the disadvantage of the C corporation. And let's look at advantages of the C corporation. 1. Owners are liable only for the debts and obligations of the corporation up to the amount of their investment. 2. The mechanisms of raising capital is easier. 3. No restriction exists on the number of shareholders, which differs from subchapter S corporations. 4. Stock is liquid if traded on a major stock exchange. 5. The ability to share stock with employees through stock options or other incentive plans can be a powerful form of employee motivation. There are also some disadvantages. One of the disadvantages is setting up and maintaining one is more difficult than for a sole proprietorship or a partnership business. Business losses cannot be deducted against the shareholders' other sources of income. That is a disadvantage. Income is subject to double taxation. It's a disadvantage. And this means that it is taxed at the corporation and the shareholders' levels. Small shareholders typically have little voice in the management of the firm, so it is a disadvantage. Now let's look at the subchapter S corporation. The subchapter S corporation combines the advantages of a partnership and a C corporation. And it is similar to a partnership in that the income of the business is not subject to double taxation. The subchapter S corporation is similar to a corporation in that the owners are not subject to personal liability for the debts or behavior of the business. It does not pay taxes. That is, a subchapter S corporation does not pay taxes. Profits and losses are passed through to the tax returns of the owners. There are strict standards that a business must meet to qualify for the status as a subchapter S corporation, and these include: 1. The business cannot be a subsidiary of another corporation. Then the shareholders must always be citizens of the state or of the country. Partnerships and C corporations may not own shares in a subchapter S corporation. Certain types of trust and estates are eligible to own shares in a subchapter S corporation. 3. It can only have one class of stock issued and outstanding, either preferred stock or common stock. It can have no more than 100 members. Husbands and wives count as one member, even if they own separate shares of stock. All shareholders must agree to have the corporation formed as a subchapter S corporation. So, having discussed what sole proprietorship is, partnership is, and corporation is, let's look at what limited liability company is. So when we talk about the limited liability company, we are talking about business ownership that is now rapidly gaining popularity in most countries. Along with the subchapter S, it is a popular choice for a startup firms. So which means that startup firms can begin or can think of subchapter S companies, corporations, or limited liability companies. The limited liability company combines the limited liability advantage of the corporation with the tax advantages of a partnership. A limited liability company does not pay taxes. Profits and losses are passed through to the tax returns of the owners. So please take note of that. Advantages of a limited liability company. Members are liable for the debts and obligations of the business only up to the amount of their investment. The number of shareholders is unlimited. So an LLC, that is the limited liability company, can elect to be taxed as a sole proprietor partnership, S corporation, or corporation, providing much flexibility. Because profits are taxed only at the shareholders level, there is no double taxation. So take note, the profits are taxed only at the shareholders level, not at the corporation level or at the business level. What are some of the disadvantages when it comes to the LLC? Setting up and maintaining one is more difficult and expensive. Tax accounting can be complicated. Number 3, some of the regulations governing LLCs vary by country. So depending on which country you want to operate in. Because LLCs are a relatively new type of business entity, there is not a much legal precedent available for owners to anticipate how legal disputes must affect or might affect their business. Some countries will levy a franchise tax on LLCs, that are limited liability companies, which is essentially a fee the LLC pays the country for the benefit, the country or the state for the benefit of limited liability. So this is how far we have come.